If you work in quality control at a candy factory, you know strict safety regulations come with the job. It's why you partner with Grainger. Grainger helps you find the high-quality and compliant products your business needs to inspect, detect, and help correct issues. And the sweetest part is, everyone gets a product that's as safe to eat as it is delicious. Call 1-800-GRAINGER, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
Hey everyone, and welcome back to Exposed, Scandalous Files of the Elite. I'm your host, Jim Chapman, and we have come a long way to get to this aspect of the Murdaugh series, and that is the verdict in the state of South Carolina versus Alec Murdaugh for the murder of his wife, Margaret Maggie Murdaugh, and his son, Paul Murdaugh. Now, when I last left you, prosecutors and defense, they had completed their closing arguments, and something shocking happened just prior to those closing arguments that would weigh heavily on the case, and that was the removal of a juror, which, hey, it's a huge deal. The entire case is nearly complete. You're down to closing arguments, and a juror has to be removed. Not good. And Judge Clifford Newman, he did a masterful job of explaining why. And here's that clip.
First off, this morning we have to deal with the issue involving the removal of a juror. A few days ago, I received a complaint from a member of the public indicating that a juror had engaged in improper conversations with parties not associated with the case. I communicated and provided a copy of the communications to the defense counsel. After court, we then met with the juror on the record, and the juror denied denied discussing the case with anyone not on the jury or with anyone on the jury. She provided information that led us to the court to contact the persons that she was suspected of having conversations with concerning the case. Those individuals were interviewed and provided an affidavit regarding the contact that the juror had with them. We then also brought those two individuals in and had a hearing in chambers on the record in the presence of counsel yesterday. In which both of those individuals waffled on the nature and the extent of the contact. They also provided a recorded interview, or the state provided a recorded interview with the jurors, and I reviewed that interview last night. So the juror has had contact or discussions concerning the case with at least 3 individuals. Though it does not appear that the conversations were that extensive, it did involve the juror offering her opinion regarding evidence received up to that point in the trial that the conversation took place. And in order to preserve the integrity of the process and the interests of both the state and the defense in a fair trial, that juror will be removed and replaced by another juror. I will make a part of the record under seal because of maintaining the confidentiality of the identity of the jurors. I will place under seal the recorded interview, affidavits received, and both discussions with counsel have taken place on the record, and all of that will be made a part of the record. In the case. And we'll bring the juror out to inform her that her services will no longer be needed. We will then replace her with an alternate juror. Any additional comments by the state or the defense?
Not from the state, Your Honor.
Your Honor, we do not accept from your ruling.
Yes.
I've sat through everything you sat through, and it's muddled, but we would defer to your judgment. However, I think it's important for me to note for the record that the interviews of these two people were done by SLED agents, one of whom was named as a witness in this case, and the other who was listed in the notes as being one of the investigating officers. Just to note that, again, SLED has made another bad judgment in this case. I'm not accepting from your ruling.
Yes, sir.
I'm just pointing out that this is just a continuum of a calamity of errors. Thank you.
And the court has not had any discussion with any SLED agents concerning this issue. And all the inquiry by the court has been directly with the suspected parties involved and with the juror. And this is a matter that this long trial with the intense publicity is certainly, it would be certainly difficult for any individual to not have some exposure outside of the courtroom to information concerning the case and to also be tempted to engage in discussions with others. But it is improper, it is contrary to my instructions to the jury daily, multiple times per day, and this juror unfortunately violated that order. So if you will bring out juror number 785. Let's make sure she brings everything with her. Good morning. Yes, ma'am, up here. In your normal spot's fine. If you could just remain standing for me. Good morning. You doing okay today? All right. I have, as you know, we've had some discussions with you over the past couple of days concerning indications of conversations with few folks not on the jury concerning the case and expressing some opinion about the case. I have reviewed everything, including statements given by individuals and recorded interviews, and concluded that despite my order to not discuss the case with anyone, that intentionally or unintentionally you've had some discussions with some folks not on the jury, and which is going to require me to remove you from the jury. You have been a by all accounts, great juror and smiled consistently and have seemingly been attentive to the case and performed well. And I'm sure that with all the time you've invested in it, you probably hate not to continue, or maybe you're ready to go. I don't know. But I certainly want to thank you for your service. I'm not suggesting that you intentionally did anything wrong, but that in order to preserve the integrity of the process and in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs.
One of the other jurors brought in eggs for everybody.
Oh, okay.
Eggs in my purse and nut water.
All right, well, you're going to leave the eggs. You want to leave the eggs or take the eggs? You're going to take the eggs. So, Mr. Bailiff, can you retrieve from the jury room her dozen eggs, her purse, and what else? And a bottle of water. If you can get those things from the jury room. As you know, the identity of the jurors are confidential, not known to the public, and the reason you are still where you are is that cameras are not allowed to videotape the jurors, and we have operated by juror numbers throughout the process, and we'll continue to do so, and your identity will be kept confidential as far as the court is concerned. And we trust that in the event you decide you want to speak publicly about this case, that you wait until after the case is over. You're not encouraged at all to do so, but you have a right to speak to anyone you want to, if you decide to do so. No, I have not spoken with her today, but no, this is not related to, I know we also had some conversation was brought up concerning your ex-husband, but that's not a part of this consideration at all. This is totally independent of any other conversation that he might have had concerning you. That's not part of the order of the court. So they're going to get your things, and then once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. Hey, you can go. Thank you. We get a lot of interesting things, but now a dozen eggs. It's certainly pretty interesting. We'll give her a chance to leave or to take her. She's gone? Yes, sir. Okay, very good. Anything else before the jury comes?
Have we picked an alternate?
Oh, right, absolutely. When they come out, we'll need to select an alternate, and the clerk you have the remaining alternates in a box. Any objection to a blind selection of that alternate out of the box?
Nothing from the defense, Your Honor.
So, not good, especially as it relates to the appeals process. And it's worth mentioning that the juror removed had told sources they would not have found Murdaugh guilty, which, remember, the guilty verdict would have to be unanimous in order to avoid a hung jury and a retrial. So that juror is replaced with an alternate. And quickly, an alternate is just like a regular jury member. They're there the whole time as well, and they sit through everything the regular jury sits through. So there's no catching up that they have to do or anything like that. So at this point, the jury, they receive instruction for deliberations, and everyone, defense, prosecution, they're settling in for maybe several days of deliberations. Well, to the shock of everyone, and I mean everyone in that courtroom and around the world, just 3 hours into deliberations, the jury sends a note to the judge saying they have come to an agreement and a verdict. And here is that.
Madam Forlady, if you'll stand for me. Have you reached a verdict?
Yes, sir, we have.
Is it unanimous?
Yes, sir, it is.
All right, if you will pass it up to the clerk, who will pass it to me. The defendant will rise. Madam Clerk, you may publish the verdict.
Docket number 2022 GS 15 00592, the State of South Carolina, County of Colleton, in the Court of General Sessions in the term of 2022, July, the State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116. You want me to turn anything? Okay. Guilty verdict. Signed by the forelady, 3-2-23. Docket number 2022-GS-15-00593, the State of South Carolina, County of Colleton, in the Court of General Sessions, the July term of 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116, verdict guilty, signed by the forelady, date 3/2/23. Docket number 2022-GS15-00595, the State of South Carolina, County of Colleton, Court of General Sessions, July term 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for possession of a weapon during the commission of a violent crime, SC Code -16-23-0490, CDR Code 0549, verdict guilty, signed by the foreperson of the jury, date 3/2/23. Docket number 2022 GS-15-00594, the State of South Carolina, County of Colleton, Court of General Sessions, July term 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for possession of a weapon during the commission of a violent crime, SC Code 16-23-0490, CDR Code 0549, verdict guilty, signed by the foreperson of the jury, 3/2/23.
Thank you. Madam Forelady and members of the jury, if that is the verdict of each and every juror, please let it be known by raising your right hands. All right, thank you. Any individual polling requested?
We do, Your Honor.
Madam Clerk, you'll need to individually poll the jury according to their juror numbers.
Number 193. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 254.
Yes.
Is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 326. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 530. Was this your verdict?
Yes.
Is this your verdict?
Yes.
Juror 544.
Yes.
Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 572. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 578. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 589. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 630. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 729. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 826. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 864. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Your Honor, the jury has been polled.
Thank you. The jury has been polled and the verdict is a unanimous verdict. If you will bring the alternate juror out and have her have a seat in the audience, please. You can stand there or you can sit back there, whatever you prefer. Okay. Are there any post-trial motions?
None from the state, Your Honor.
Your Honor, we would just renew our previously argued motions for a directed verdict, and at this, on the grounds, on those grounds, we would make a motion for a mistrial and to set aside the verdict.
By the state, response.
Your Honor, based on our previous arguments, we would submit that the case properly went to the jury and the verdict was proper, and we rely on those arguments.
We've been here now 28 days, first few days of jury selection, and the remainder receiving testimony, an overwhelming amount of testimony and evidence that was presented to the jury for the jury's consideration. As I indicated to the jury during the jury charge, or the charge on the law, that this was a matter solely for the jury to determine. The court found at the end of the state's case that there's sufficient evidence to find the defendant guilty if the evidence was believed by the jury. Likewise, at the end of the defense's case, when the motion was renewed, the court found that the evidence was sufficient for the jury to find the defendant guilty. The jury has now considered the evidence for a significant period of time, and the evidence of guilt is overwhelming, and I deny the motion. Mr. Murdaugh, you now having been found guilty of 2 counts of murder involving your wife and your son, 2 counts of possession of a weapon during the commission of a violent crime, the burden now comes upon the court to impose a sentence. Given the lateness of the hour and the victim's rights that must be taken into consideration and complied with under the Victim's Bill of Rights, and consider what I would anticipate to be a number of people who might have something to say regarding sentencing, we will defer sentencing to a later date. Of course, the minimum sentence for murder is 30 years. The maximum sentence is life imprisonment as to each count. And on the weapons charge, the sentence is up to 5 years, or 5 years, which has to be concurrent if a life sentence is imposed. When would you all like to reconvene for sentencing? I would like to give everyone an adequate opportunity to prepare for it.
State will be ready at 9:30 in the morning, Your Honor.
We could do it at 9:30 tomorrow morning also.
All right. The defendant is remanded to the custody of the Colleton County Sheriff's Department. Madam Floor Lady and members of the jury, I want to thank you on behalf of the citizens of the state of South Carolina and your fellow citizens of Colleton County. You did not volunteer for this service. You were called upon by being summoned to appear, and Providence have brought you to this moment in time and these weeks in time. I know that all of you have been here at great sacrifice, particularly the juror whose job was on the line until a miracle happened, I guess, that allowed him to be able to leave rather than leave after 2 or 3 weeks. But I want to thank each one of you all individually and collectively. It's not often that you're called upon to sit in judgment of the actions of your fellow man, but you all responded and gave due consideration to the evidence. I will make no comment now as to the extent or the overwhelming nature of the evidence, but certainly the verdict that you've reached is supported by the evidence, circumstantial evidence, direct evidence, all of the evidence pointed to only one conclusion. That's the conclusion that you all reached. So I applaud you all for, as a group and as a unit and individually, evaluating the evidence and coming to a proper conclusion as you saw the law, as you saw the facts. Now that you've served for the next year, you're not eligible to serve again. Now, of course, many people never get called upon, but you're not eligible for the next year, and for 2 additional years, you can be exempted from service because no person is required to serve on jury duty in this court more often than once every 3 years. Tomorrow morning at 9:30, we will reconvene for sentencing. You all have no role in that because that's solely up to the judge, to me. You're welcome to come back if you want to and be a part of the audience if you like. I also want to thank the alternate juror who was locked away in a room by herself for these hours, who's hung in there during that period of time. I want to thank you as well. Madam Clerk, what do you have to tell your jurors?
Thank you for your service and what the judge said as well. And I think we can release them tonight and bring them back in the morning.
No, they're off jury duty. They can come back if they like. And you don't have to if you don't want to. Typically, I've seen jurors wanting to see the end result of a case once they've invested a lot into it. It's really an amazing thing with juries. Quite often, at the start of the case, jurors are really like, whoa, why am I here? I wish I wasn't selected. But as time passes and the jurors become invested and really committed to the case and committed to seeing it through, and are very disappointed when they are not able to see it to a conclusion. And then along the way of serving, you end up finding out quite a bit about our judicial system and learning quite a bit, about human nature for sure, but also about the presentation of evidence and hearing from expert witnesses and really learning a lot of things that you'll be able to take with you when you leave jury duty. And to Madam Forelady, I don't know if you were hesitant initially or not, but you have stepped up to the plate and done a great job of leading the jury as well. And thank all of you. So the jury is dismissed. Now, one thing before you go, of course, we have invested a lot in maintaining the privacy of the jury, of each one of you. And you are free at this point to discuss the case with anyone. Given the high-profile nature of the case, I'm certain that the many people in the media will probably want to communicate with you, but they have no means of contacting you because under order that I issued, the identity of the jurors must be kept private. And If you decide that you want to speak with anyone, local, state, nationally, or internationally, that's your prerogative. However, should anyone harass you, please let me know and I will address those issues. If anyone through the somehow or another discover your identity and harass you, and rest assured I will intercede on your behalf. That having been said, you are free to communicate with whomever you might want to concerning the case from now on. And so with that, thank you, and you all are free to go.
Now, I'm going to reference two articles here from Fit News that really did an amazing job of covering the verdict and its implications. And here is how those two articles read. The first is titled, "Disbarred South Carolina Attorney Alex Murdaugh Found Guilty on All Counts in the Brutal Double Homicide of His Wife and Son in Colleton County on Thursday Evening." And it goes on to say, after less than 3 hours of deliberations, 12 jurors returned the unanimous murder verdicts along with 2 guilty verdicts on associated weapons charges. "I'm sorry," Murdaugh mouthed to his surviving son, Buster Murdaugh, as he was handcuffed and led out of the courtroom. "I love you. I love you." Buster Murdaugh, who testified on his father's behalf, offered no visible response to his father. Murdaugh will be sentenced tomorrow by South Carolina Circuit Court Judge Clifton Newman, who's expected to impose back-to-back life sentences on 2 murder charges and additional years behind bars on the 2 weapons charges. Upon being sentenced, Murdaugh will be transferred at some point to the custody of the South Carolina Department of Corrections. Murdaugh will be handcuffed, shackled, and dressed in prison garb upon his arrival at the Colleton County Courthouse on Friday, representing a stark visual departure from his appearance over the past 6 weeks in jackets, dress shirts, and slacks. Why the change? Because Murdaugh is now a convicted murderer, not an accused killer. The dramatic conclusion to the Palmetto State's trial of the century almost didn't happen, though. Prior to the removal of a juror earlier in the day, sources familiar with the deliberations indicated Murdaugh's trial, which drew international attention, would likely have ended in a hung jury. Newman removed the juror in question for having improper conversations with 3 individuals about the case. The juror allegedly lied to Newman about these communications, which violated his order that jurors are not to discuss the case with anyone or each other. Newman removed her in order to protect the integrity of the process. Quote, "You have been, by all accounts, a great juror," Newman said, telling her she had been attentive to the case. Newman added he was not suggesting she intentionally did anything wrong and thanked her for her service. Her removal paved the way for a guilty verdict just hours later. She was dug in, a source familiar with the deliberations confirmed. She said he was not guilty and there was nothing anyone could do to change her mind. She would have hung the jury, another source confirmed. Y'all, and that's huge. Now, at approximately 6 p.m., the jurors indicated to court officials they would not need to have dinner delivered to them. This was the first indication that the lone holdout on the panel had been swayed. The next indication came as one of the bailiffs in the courtroom instructed members of the gallery at around 6:50 p.m. to refrain from making any sounds whether you agree with the verdict or not. After that, things moved fast. Judge Newman entered the courtroom, announced the verdict had been reached, and 3 minutes later, he addressed the forewoman. And of course, we played that verdict for you. And I'm just going to read this other article they put out there at Fit News that references Alex Murdaugh's decision to actually testify in his own defense. And it says a South Carolina jury convicted former lawyer Alex Murdaugh of murdering his wife and son after less than 3 hours. Jurors did not ask to have any testimony reread or see any evidence again. Quote, "It was one thing for them to come to a rather quick decision, meaning a day or two, if they were going to find Alex Murdaugh guilty. It's another thing to come to the decision within 3 hours, a legal analyst said. And then it goes on to say the most likely explanation was Murdaugh's decision to take the stand. While testifying, the embattled lawyer admitted that he lied about his whereabouts the night of the murders. The prosecution also had a video from Murdaugh's son's phone that proved that Murdaugh was at the site of the murders with his wife and son just minutes before they were killed. South Carolina Attorney General Alan Wilson, who was one of the prosecutors in the case, also said that Murdaugh's decision to take the stand hurt him. I think it hurt him 100%. I think ultimately it hurt him in the end. This is a person who has spent his entire career, was very successful, making millions of dollars making closing arguments to a jury. And I guess in the back of his mind, he probably believed this is his opportunity to make this final closing argument. He's been manipulating people for decades, lying and manipulating to get his way. And I feel like he thought he could do this to a jury. That's probably what he was thinking, but it blew up in his face. And so I could not agree with that anymore. I think that was a major mistake on Murdaugh's part. Now, honestly, no one was happier with this verdict than the state of South Carolina, the Attorney General of South Carolina, and of course, Creighton Waters, who took on a titan and destroyed him, quite frankly. Here is what he and that Attorney General said immediately following that verdict.
Wow, what a great day for the people of South Carolina. I want to thank every one of you for being here tonight. There's a lot of emotion here tonight at this courthouse. A lot of a year and a half, nearly 2 years of blood, sweat, and tears, it feels like. A lot of hard work from so many people. So if you will just bear with me, there's a lot of people I have to thank. But first, those of you who don't know, I'm Alan Wilson. I'm South Carolina's Attorney General, and I got the best staff of any Attorney General in the United States of America. I want to start by thanking our prosecution team. I want to tell you, I've been here for nearly 6 weeks with this team, living in a hotel, and it felt almost like being in a dorm environment in college. Late nights, cramming, studying, little sleep, away from our families, getting up early, getting here to the courthouse, working long hours, getting on each other's nerves at times, but it was all worth it. It was all worth it because we got to bring justice and be a voice for Maggie and Paul Murdaugh and bring justice for the people of South Carolina. I'd like to start real briefly by thanking our team. First, excuse me, let me put my glasses on. Our chief prosecutor, I tell you, I appointed Creighton Waters to be the chief prosecutor of this case nearly a year and a half ago. And I want to say I'm pretty brilliant because I picked the right guy. And I want to say thank you to Creighton Waters. Creighton, you did a fantastic job. I don't think there's another attorney in the state of South Carolina that could have led this Herculean effort. But Creighton will be the first to tell you he didn't do it alone because he had a team of people. I want to first thank Don Zelinka, who is actually Creighton's boss. He is the Deputy Attorney General, been in the Attorney General's office for over 40 years. Sitting here to my immediate left, Don Zelinka, thank you so much. John Metters, many of you got to see him do the closing argument today. John, thank you. You've been a phenomenal add to our team. I'm going to go quickly through the names, but as I read the names, please raise your hand. You know Creighton, you saw Don, and you see John. David Fernandez, John Conrad, Johnny James, Savannah Gowd, Ozzie Toledo,
Yes.
Shane Acito,
Yes.
Carly Jewell,
Yes.
Carson Burney,
Yes.
Danielle Colon,
Yes.
and our victims advocate, Tricia Allen.
Yes.
I also want to say thank you to the South Carolina Law Enforcement Division. Mark Keel assigned some amazing men and women. And when I say it was an agency-wide effort on behalf of SLED, I can't underscore that part enough. Every time I called Chief Keel, every time I reached out to the lead agents, every time Creighton was asking me, hey, General, we need something from SLED, we would reach out to SLED, and they were there. They busted their butts. I can't begin to list every agent, and some can't be listed for obvious reasons. Some are standing up here tonight. I told them I wasn't going to mention their names, but we would not be here if it wasn't for SLED. And I want to thank Mark Keel and his team and all of the men and women across the entire state law enforcement division for what they did to make tonight a possibility. Amen. I also want to thank the FBI and the Secret Service, our federal partners. We had to utilize many of their assets and resources. We couldn't do all the things that we did without our federal partners. We had a lot of local partners. We had the Colleton County Sheriff's Department, Buddy Hill, Sheriff Hill and his team, providing the security. They did a phenomenal job, and they were there. They were the first responders the night on June 7, 2021, when Maggie and Paul were butchered brutally. They were the first responders, and they were the first ones to be there. The Charleston County Sheriff's Office, the Orangeburg County Sheriff's Office were instrumental in supporting our investigative efforts. You all know Kenny Kinsey, our chief crime scene expert, was with the Orangeburg Sheriff's Office. I also want to thank the city of Walterboro. I think the mayor is here somewhere, and the police department. They provided security. Thank you. This whole community has embraced our entire team, and I cannot thank you enough. We've all been away from our families, 2 hours away from our families for the past 2 months. And it's this community that made us. We would walk into restaurants and people would come up and thank us. You know, you don't have any idea how good that makes people feel when they're under an incredible amount of stress, an incredible amount of scrutiny, and this community really embraced us. I want to thank the Colleton County Clerk of Court, Becky Hill, and her entire team and their staff. I call her Becky Booth. That's her nickname. But Madam Clerk, wherever you are tonight, I'm sorry. That's my pet name for her. But I want to thank you, Madam Clerk, for you, the entire team, the bailiffs, the court security, the staff here. There was no role that was too small that they weren't willing to do for us. The security team here, it was a Herculean effort by everybody, and I can't thank enough people. I don't know if I mentioned the bailiffs, but I want to thank them. And there's another group of people who you don't know who they are, but that's the jurors. And not just the jurors, but the alternates, the ones who didn't even get to serve to the very end, but people who were taken away from their families. And I want to thank the families of our jurors who sat here every single day for what seemed like long amounts of tedious, monotonous information and evidence. Sometimes people didn't know what it meant. They didn't understand it. And they had to sit there and process it and hear it over and over and over again. And I want to thank these nameless jurors whose identities have been protected. They may make their identities available to all of you at some point, but they sat there and they delivered justice tonight, and I want to thank them for their role in this process. Amen. You know, Winston Churchill said, democracy is the worst form of government except for every other kind. I kind of want to adopt that and say we may have the worst criminal justice system in the world, but it's better than every other kind that there is. And our criminal justice system worked tonight. It gave a voice to Maggie and Paul Murdaugh, who were brutally mowed down and murdered on the night of June 7th, 2021 by someone that they loved and someone that they trusted. And they couldn't be here to testify for themselves tonight. Their testimony came through the evidence and the information that was gathered by the men and women of the agencies I've just mentioned. It came from the testimony of the agents and the investigators and the attorneys and the folks in our staff who were able to get it to the court record. And so I want to say tonight, their voice was heard tonight and justice was brought for them. We can't bring them back, but we can bring them justice. Amen. Amen. I started off my remarks by saying that it is a good day in South Carolina. Yes, it is. Yes, it is. Today's verdict proves that no one, no matter who you are in society, is above the law. Amen. Thank you. Thank you. A lot of people doubted that this process would work, and hopefully, for those who did doubt the process, hopefully we have instilled and put a little bit of faith back into you and your lives as you view this process as it unfolds. I'm proud of this team. I'm proud of the men and women standing behind me tonight. And there's been a lot of emotion. And I just want to say from the bottom of my heart, I saw firsthand for the last 5 or 6 weeks the countless nights where you were up beyond midnight and you were getting up before dawn, not eating, watching Nancy Grace the other night, and I heard her call Creighton pale and gaunt because Creighton wasn't eating and sleeping. He really wasn't, folks. I'm serious. You know, we would have to bring in kind bars and things to eat during breaks. But Creighton, Herculean effort, my friend. And I am truly honored to have you on our team. Thank you for being a great leader and a great chief prosecutor. And I would like to invite you to come up here and make some remarks for the folks here tonight.
Thanks, everybody. And I'll start by thanking this guy who's given me and all these folks behind us opportunities to do justice, which is what we want to do with our careers. It is very tough and demanding, but it's rewarding for moments like these. The general stole a lot of my lines, but I also want to thank the jurors for their long and arduous service. And we had no doubt that if we had a chance to present our case in a court of law, that they would see through the one last con that Alec Murdaugh was trying to pull. And they did, and we're so grateful for that. I get to lead the state grand jury section in the Attorney General's office. This particular case is not a state grand jury case. There are other indictments that are state grand jury. But the one thing about that is that I have an amazing team. And I want to be clear, this was a team effort. Y'all saw all of these folks behind me doing amazing work. And I can't be prouder of a team in my life. We called this our Super Bowl, and not because of the media attention, but just because of the effort that we knew that we would have to put into this. And we didn't really get to watch much of the Super Bowl that went on because when we arrived, I think it was winter, and it feels like spring now. But every single member of this team, every single member of the state grand jury staff, what we do well is work together as a team in complex investigations, and who we work with is my partners at SLED. And I can't thank them enough as well, because we're used to working on these complex cases and working together. And I'm not leaving out Sheriff Hill and the Colleton County Sheriff's Office and our federal partners in Orangeburg and Charleston Sheriff's Office and all the other agencies that have worked on this case. I also want to thank Miss Becky, if she's still up there, because she's been amazing. The clerk staff has been amazing. The court staff has been amazing. The bailiffs have been amazing. And again, I also want to thank this community who really has embraced us and has been so great to us and made us able to survive this process that has been long and arduous. And I have been sleeping. I haven't been. And I have been eating more than Kind bars every now and then. But, and I'm sure that's a nice plug for Kind. But anyway, it really has been a great process. We will have sentencing tomorrow. Obviously, we're not going to comment on sentencing because that's still pending. But justice was done today. It doesn't matter who your family is. It doesn't matter how much money you have or people think you have. It doesn't matter what you think, how prominent you are. If you do wrong, if you break the law, if you murder, then justice will be done in South Carolina. And I think South Carolina has shown to the nation and the world how a process can work and work well. Amen. Thank y'all.
And also, I want to thank Creighton. I told Creighton, I said, Creighton, I'm going to come down and I'm going to be just a staff attorney. I know I'm your boss. I'm your boss's boss's boss. But I said I'm going to come down and I'm going to help. And I said I'm going to follow instruction, and I hope I was true to my word. This past weekend, I was saying, what can I do to help? I said I'm willing to take a witness if it'll help. He said actually it would. So he let an old prosecutor dust off his cleats and get back in the game and to help the team out. And
I got to be the boss of the boss for a while.
Yeah, don't get used to it.
I'm not used to it.
No, but in all seriousness, I'm proud of the decisions that I made in putting the people behind me and to the left and right of me in charge of this case, and I was honored to be part of this team. Just another member, just another worker bee in the trenches trying to bring justice to the people of this state, and to bring justice to the people who couldn't be here tonight because they were brutally murdered by someone they trusted. Now, with that being said, I know a lot of people want to talk to us. A lot of people want to talk to some of the attorneys and the support staff and the agents, investigators here tonight. Some of you want to talk to me and others. We're going to make ourselves available to you. But like Mr. Waters just said, tomorrow there's a sentencing hearing, and we don't want to get out in front of our skis. And plus, I'm starting to feel the rain come down. But I promise you, we're going to make ourselves available to talk to members of the media, to talk to all of you out there that have questions. We'll answer any questions that we ethically can.
So there you have it. And all that is left for Murdaugh is the sentencing phase. And it is at this point that we really hear how much thought Judge Clifford Newman put into this case. When he sentences Murdaugh, it is really an amazing speech that you've got to hear. This is what it sounded like.
This has been perhaps one of the most troubling cases, not just for me as a judge, for the state, for the defense team, but for all of the citizens in this community, all the citizens in this state, and as we've seen based on the media coverage throughout the nation. You have a wife who's been killed, murdered, a son savagely murdered, a lawyer, a person from a respected family who has controlled justice in this community for over a century, a person whose grandfather's portrait hang at the back of the courthouse that I had to have ordered removed in order to ensure that a fair trial was had by both the state and the defense. And I've sat through the trial. Not only have I sat through the trial, but also as the presiding judge of the state grand jury, sat through and participated in the issuance of search warrants of various sorts, bond hearings, and have had to consider many things. And we have this case, and I'm also assigned to preside over 99 others, at least 99 other cases. Though testimony has come up regarding many of those other cases, I will not make any comment with regard to any other pending matter, as I have been assigned those cases as well. It's also particularly troubling, Mr. Murdaugh, because as a member of the legal community and a well-known member of the legal community, you've practiced law before me, and we've seen each other at various occasions throughout the years. And it was especially heartbreaking for me to see you go in the media from being a grieving father who lost a wife and a son to being the person indicted and convicted of killing them. And you've engaged in such duplicitous conduct here in the courtroom, here on the witness stand, and as established by the testimony throughout the time leading from the time of the indictment and prior to the indictment throughout the trial to this moment in time. Certainly, you have no obligation to say anything other than saying not guilty. And obviously, as appeals are probably expect it or absolutely expect it. I would not expect a confession of any kind. In fact, as I've presided over murder cases over the past 22 years, I have yet to find a defendant who could go there, who could go back to that moment in time when they decided to pull the trigger or to otherwise murder someone. I have not been able to get anyone, any defendant, even those who have confessed to being guilty, to go back and explain to me what happened at that moment in time when they opted to pull the trigger, when they opted to commit the most heinous crimes known to man. In this case, qualifies under our death penalty statute based on the statutory aggravating circumstances of two or more people being murdered by the defendant by one act or pursuant to one scheme or course of conduct. I don't question at all the decision of the state not to pursue the death penalty. But as I sit here in this courtroom and look around the many portraits of judges and other court officials and reflect on the fact that over the past century, your family, including you, have been prosecuting people here in this courtroom, and many have received the death penalty, probably for lesser conduct. Remind me of the expression you gave on the witness stand. Was it tangled?
Tangled web, we weave.
Oh, what tangled web we weave. What did you mean by that?
It meant when I lied, I continue to lie.
And the question is, when will it end? When will it end? And it's ended already for the jury because they've concluded that you continued to lie and lied throughout your testimony. And perhaps with all the throng of people here, they, for the most part, all believe, or 80, 90%, 99% believe that you continue to lie now when your statement of denial to the court. Perhaps you believe that it does not matter, that there's nothing that can mitigate a sentence given the crimes that were committed. You know, a notice of alibi was filed in this case by counsel in November, and we conducted a hearing, pretrial hearing, in which you claimed to have been someplace else at the time the crime was committed. Then, after all of the witnesses placed you at the scene of the crime, at the last minute, or last minutes or days, you switch courses and admitted to being there. And then that necessitated more lies and continued to lie. And I said, where will it end? It's already ended for many who have heard you and concluded that it'll never end. but within your own soul, you have to deal with that. And I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you. I'm sure.
All day and every night.
Yeah, I'm sure. And they will continue to do so. And reflect on the last time they looked you in the eyes, as you looked the jury in the eyes. I don't know person who's always been such a gregarious, friendly person and cause your life to be tangled in such a web, such a situation that yours have spun into. And it's so unfortunate because you had such a lovely family of such friendly people, including you, and to go from that to this. Your license to practice law has been stripped away from you. You turned from lawyer to witness, and now have an opportunity to make your final appeal as an ex-lawyer. And it's really surprising that you're waiving this right at this time. And if you opt to do so, it's on you. You're not compelled to say anything. But you have the opportunity to do so.
Judge, I tell you again, I respect this court, but I'm innocent. I would never, under any circumstances, hurt my wife, Maggie, and I would never, under any circumstances, hurt my son, Paw.
Well, and it might not have been you. It might have been the monster you become when you take 15, 20, 30, 40, 50, 60 opioid pills. Maybe you become another person. I've seen that before. The person standing before me was not the person who committed the crime, though it's the same individual. We'll leave that at that. Before announcing sentence on these cases, with regard to all of the other pending cases, are any of them here in Colleton, or I'm sure some of them are?
Yes, sir.
Half of them, or?
I don't have that in front of me, but there are a substantial number of charges here. There's some in Hampton, Orangeburg, Beaufort, Allendale. There may be others that I'm not thinking of right now.
We might have worn out our welcome here in Colleton. They have been, and I'll take this opportunity to thank Sheriff Hill and all of the court officials and really everyone I've met and dealt with while here in Colleton County. Just been great. But without any delay, we're going to schedule some of the other matters. I know Mr. Harpootlian's scheduling is complicated, and you've sacrificed quite a bit to be able to be here defending Mr. Murdaugh, as well as the Attorney General's office, with all the other many things and obligations you have. And to be able to have the Attorney General here, Alan Wilson, for the period of time that he's devoted to being here, along with everyone else, it's been quite a sacrifice. But there are other victims whose cases deserve to be heard. And this case has jumped some of those other cases. Perhaps jumped it because of this case resulting in an assault on the integrity of the judicial system in our state, law enforcement in our state. Even during this trial, the law enforcement have been maligned for the past 5 or 6 weeks by one who had access to the wheels of justice, to be able to deflect the investigation. And as the evidence is pointed out in this case, the looming storm that Mr. Waters talked about, I can just imagine on that day, June 7th, when a lawyer is confronted and confesses to having stolen over $500,000 from a client, and he has a tiger like Mark Tinsley on his tail pursuing discovery in the case involving the death of Mallory Beach, and having a father, for the most part, on his deathbed. I could imagine, or really can't imagine, but I know it had to have been quite a bit going through your mind on that day. But amazingly, to have you come and testify that it was just another ordinary day, that my wife and son and I were out just enjoying life. Not credible, not believable. You can convince yourself about it, but obviously you have the inability to convince anyone else about that. So if you made any such arguments as a lawyer, you would lose every case like that. Cases you will never have an opportunity to argue anymore, except perhaps your own as you sit in the Department of Corrections. Anything further?
No, sir.
All right, Mr. Murdaugh, I sentence you to the State Department of Corrections on each of the murder indictments in the murder of your wife, Maggie Murdaugh. I sentence you for the term of the rest of your natural life for the murder of Paul Murdaugh, whom you probably loved so much. I sentence you to prison for murdering him for the rest of your natural life. Those sentences will run consecutive. Under the statute involving possession of a weapon during a violent crime, there is no sentence where a life sentence is imposed on other indictments. That is the sentence of the court, and you are remanded to the State Department of Corrections. And officers may carry forth on the imposition.
Now, after the sentencing, the defense in this case, they had a few words to say outside of the courtroom themselves, and here's what that sounded like.
I'm Dick Harpilian. This is Jim Griffin. That's Emily Dale. That's Maggie Fox. That's Holly Miller. And this is Phil Barber. We are Alec Murdaugh's defense team. We're able to answer your questions. We're not going to make a statement. I know y'all don't want one. So, anybody got a question?
Do you think it was a mistake to put Alex Murdaugh on the stand?
No. Next.
Mr.
Mr. Herculean, why did you object to that juror being dismissed yesterday?
Why didn't I?
Why did you?
Well, for two reasons. One, she admitted she talked to other people about the case, but not specifically. But technically, I think the judge had leeway to excuse her, but she clearly, after we interviewed her back in chambers, in my mind, had not made up her mind. And I thought that was important.
Do you think she would have held her case?
I don't know. She didn't express an opinion to us. She said she was open. She hadn't made up her mind.
Why?
I think there were significant issues, but I won't be addressing that in the Senate unless it comes up in a bill. I'm not going to mix this role with my role as a senator. I would not do that.
Why do you think that the prosecutor like something in this case? And what do you make about the judge's comments after the verdict that he agreed with the jurors?
Go ahead. Yeah.
What now?
Death penalty question.
What was the question again? I'm sorry.
Why did they seek the death penalty?
Well, you know, I'm somebody that's prosecuted and defended a bunch of death penalty cases. And clearly, you never do it in a circumstantial case. Because you're not, 99 times out of 100, a jury's not going to sentence somebody to death without I saw him do it, he confessed, or, you know, great forensic evidence at the minimum. They had none of that here. Secondly, in a death penalty case, it gives us the ability to individually voir dire jurors, which would have been very helpful here. And the prosecution obviously didn't want that. So I don't disagree with, if I'd been prosecuting this case, I probably wouldn't have brought it, but based on, what we heard was presented to the Colleton County Grand Jury by Detective Owen that Jim crossed, blood spatter that didn't exist, testimony about guns that was wrong. I can go through the litany with you. Going back to his question, I think SLED needs to do some self-examination on the forensic processing. They did not. One of the things we complained about was that Maggie's phone would have had all her GPS data on it if they processed it within 5 days. And they because they didn't, the GPS data got overridden. It was just one, which would have been helpful to Alec. It's fingerprints, footprints, and all kinds of forensic things that weren't done. So what was the question about the judges?
What did you make about the judge's comments after the verdict? Did he agree with it and thought it was the right conclusion?
He's entitled to his opinion.
Mr. Herculean, can you expect an appeal anytime soon?
10 days we'll be filing an appeal.
What do you believe the strongest grounds for an appeal are?
What'd you say?
What do you believe the strongest grounds for an appeal are?
It was the admission of all the financial crime evidence, and that was offered up, as evidence of motive, that because he was confronted about one financial transaction involving attorney's fees by the chief accountant of the law firm, that was being offered as motive for why he would go home and kill his wife and son, which we thought was illogical and ludicrous. And there really was no evidence linking one to the other, and we did not think it should come in. Not only did that come in, but every other financial misdeed that they could bring in over the last 10 or 15 years was allowed in, and we think that we strongly objected. We respect the judge's decision, but we believe that was an erroneous decision, and we believe that the judge was somewhat misled, because at the conclusion of the case, when Mr. Metters is up on his rebuttal argument in front of the jury, he says to the jury, "Oh, forget about all that motive evidence. We don't have to prove motive. We just have to prove malice," which is right. But why did they go to all the effort to prove motive when at the end they say, "You don't have to believe us on our motive theory"? But by then they had cast Alec as a despicable human being, and that was the reason they offered it in the first place. And we think the appellate courts will take a strong look at that. We feel like that is a very solid ground for an appeal, and we're going to pursue that.
Looking back at the last 6 weeks, long trial, would you guys do anything different in the last 6 weeks?
No. No. Look, once the judge, first of all, we believe if the judge was going to let that stuff in, it should have been limited to the Ferris case, which is what they were asking him about on Monday on the fee. Number two, Tinsley, the person that made the motion to compel to be heard on Thursday, Dawes Cook, Alex's lawyer, both agreed there wasn't going to be any storm or Armageddon or anything that was going to happen that Thursday. The judge might have issued an order, which months down the line might have posed a problem. So once they got that character in it, character information is he's a thief, he's a liar, then it dictated this jury had to think he was a despicable human being and not to be believed. So it was about character. It wasn't about motive. So as a result, our options were limited. Should he take the stand? Well, we debated that. He always wanted to take the stand. But once that information was in, if he had to take the stand to explain the kennel video, the lie, if you will. He had to, but he had no credibility. His credibility had been stripped away by the financial misdeeds.
Claim today that he's innocent?
Yes.
How is Buster doing, and why did he choose not to seek the sentence?
We could have had Mother Teresa up there speaking on behalf of Alec at sentencing. He was getting a double life sentence. That was expected. This is Judge Newman. He's a very stringent punisher when it comes to crimes and sentences. That was never in dispute. And so for Buster to get up and speak on his dad's behalf would not have made a difference. And why do you want to put that kid through more trauma than anybody that we can imagine has ever been through?
Have his feelings about his dad changed at all?
What's that?
Have his feelings about his dad changed at all?
I can't speak to Buster's feelings. I can tell you this. There was a lot of effort by the state to convince the family that Alec is the murderer. The family came to trial every day for 6 weeks expecting to hear proof positive that he killed Maggie and Paul, something that they had not heard before. After 6 weeks of trial, they came away more convinced that he did not do this, and they steadfastly in his camp and support him, and that's where they stand.
What's next for Alex?
Well, Alex will be leaving shortly to go to Columbia to R&E, it's called, where he'll be at the South Carolina Department of Corrections. He'll be evaluated. That's about a 30-day process, and then he'll be sent to wherever the correctional facility that they assign him to.
They ask for any special security measures for him?
No, I don't think. Alec was not optimistic that with all of the scrutiny and press and all of his bad acts being out in the public, in the world, media domain, that he could get, a jury to put out all the noise and just focus on the murder. And so coming in, he was somewhat pessimistic. He became optimistic as we got through the process. But I got to tell you, and all you reporters, you know the whole story, I'm sure. And if you're sitting on that jury, they heard everything that would be in an HBO documentary, a Netflix documentary about the Murdaugh family dynasty downfall, except the Stephen Smith matter. So we were hoping to get a jury to put all, that could ignore the noise, focus on the murder, and we ended up trying a case that they could have watched on Netflix.
Does your legal team have any regrets about the way that you guys worked in this trial? Do you feel like you did? Do you feel like you're outmatched?
Oh, absolutely not. Not outmatched. Look, they won this case the day the judge bought into letting them put every piece of, stealing from kids who lost their mother, from somebody with pancreatic cancer, somebody that's a paraplegic. All of that 2.5 weeks, by the time they got done with it, it didn't matter about final argument. It didn't matter about what we put up. They would never, ever, ever acquit him after that.
Last question, guys.
Last question. We'll file something, not in 10 days, but we'll file a notice of intention to appeal. Then we've got 30 days, I think, to file a brief.
Yeah, so you filed a notice within 10 days. You got to get a transcript.
Oh, that'll take a while.
That'll take months before they type up everything, and then we start briefing.
Are you all going to handle the appeal
Yes.
and argue it at the Court of Appeals and the Supreme Court?
And the U.S. Supreme Court.
And the U.S. Supreme Court if necessary. That's correct.
What's the federal issue?
Doyle.
Oh, there's a huge federal issue. That's why I got so animated, and the judge told me to sit down. And part of the trial is the state eliciting or asking questions of Alec about why he did not come forward and tell law enforcement where he was at the time of the kennel video. And that was after he was arrested, and there's U.S. Supreme Court cases are clear that post-arrest silence cannot be used against you. And that is a classic violation of the Fifth Amendment. And we feel strongly that if we lose at the state courts, we'll have success at the federal.
Can you tell us about the plea negotiations before trial?
No.
There were no plea negotiations.
Because there weren't any.
They never offered him anything.
What effort are you making to find the real killer, or what effort is he making?
Not our job to find the real killer. If they had taken fingerprints, if they'd gotten footprints, if they hadn't if they preserved Maggie's phone with her GPS, if they had not, they misrepresented to the grand jury that they had a shirt with his blood on it. If Owen had opened his email, he says he didn't get, would have told him a year before there was no human blood on that T-shirt. It was a comedy of errors in terms of forensics on this. So, do I have faith that they would find the real killer? No. What? We don't know. What? Last question. Say that one more time.
Did you support putting Murdaugh on the stand?
There was no choice.
Why?
Because he had been made out to be a monster who stole from children and crippled people, and that's not a politically correct word. I'm sorry, I'm an old guy. Crippled people who had just done horrible, despicable things, and he had to try to push back on that. And if he went that way without taking the stand, he was toast. Taking the stand, could he pull it off? Apparently didn't.
In hindsight, do you regret not asking for a change of venue in this case?
Not really, because we checked. We did focus groups in this case in a county way far away from here. 8 of the 10 people on the 2 focus groups knew all about this case. There was nowhere you could go that you could find. We believe you could find a jury that didn't know, hadn't watched TV, hadn't read the stuff you write or the stuff the Twitter stuff. And by the way, one of the good piece of information now that this trial is over, Griffin can start tweeting again.
That's right.
All right, thank you guys.
So there you have it. Murdaugh goes to jail story over, right? Of course not. Not by a long shot. Becky Hill, the clerk of court for South Carolina, is about to play a big part in this case. And it seems that jury tampering is in her future as it relates to this trial. And next week, you are going to hear what she did and how it could possibly lead to the release. You heard me right. Release of Alec Murdaugh. You just won't believe it. But that's all I got for today. Tomorrow, look for those Murdaugh Jailhouse Phone Calls Volume 5 to be released. Y'all love those, so I'm going to bring you another volume. Check out the Patreon for commercial-free early releases, bonus episodes, files, and even quarterly gifts at patreon.com/exposedpodcast files. And until next time, for Exposed, Scandalous Files of the Elite, I'm your host, Jim Chapman. Much love.